products, dangerous drugs, car crash cases, injuries, and abuse. Across the state of Alabama, the attorneys of Hollis, Wright & Couch are here to serve you. With civil trial lawyer Josh Wright from the firm of Hollis, Wright & Couch and Alabama's 13 host David Lamb, the attorneys answer your tough legal questions straight ahead.
Welcome into the Attorneys Trust Your Weekend is wrapping up well. Our topic of conversation tonight is a term that you may have heard but not exactly sure what it means. Certainly I was in that boat. Alternative dispute resolutions. Josh Wright from the firm of Hollis, Wright & Couch joins us once again. And Josh, this is one of the things I like about this show, is there are terms that maybe we've heard of, not really sure what they mean, kind of shine some light on some legal jargon.
Well, that's exactly right. And alternative dispute resolution in general terms is allowing disputes to be resolved through means other than through a jury trial. And when we talk about these topics, I think they're good topics for people to understand, because most cases actually resolve. A lot of times they resolve because of alternative dispute resolution. But we bring on folks like Ken Simon from Christian & Small, great law firm here in town, actually in our building, and they represent our law firm at times. And Ken has got a mediation practice and has for years. Former circuit court judge here, so we're just honored to have him on. Ken, we're always happy to see you and glad to have you on the show. Tell us just a little bit about your mediation practice and maybe a little bit about, in general terms, what mediation is all about.
Well, thanks, Josh. I'll be glad to. Well, first of all, mediation is, as you mentioned, it's the process of trying to work out cases, get them solved and settled and resolved before having to go to trial. And what a mediator does is help the parties basically find a solution to their cases, to their civil cases usually, but there are other cases, and we'll talk more about that. So what I do as a mediator then is sit the parties down. We work through this whole process. It's like a negotiation. It's a structured negotiation process. The lawyers are not on the telephone as they might be in the old way of doing things, but instead we come to my office. And we all get into separate conference rooms, and I work back and forth with the lawyers and with the parties, taking it one step at a time to find a solution. And that's what our practice group does. We've got at our firm and what we call Alternative Dispute Resolution, or ADR, practice group. And we help resolve civil cases, like a car wreck, domestic cases, family court type situations, and other kinds of legal disputes. It's all done out of court, and it works.
And from the percentages, you talk about, Josh, you were saying that are these cases and matters of debate and argument, are they more often settled this way rather than a court of law?
Well, I think that cases can settle in a lot of different ways, and Ken would tell you, sometimes they settle with a mediator, sometimes they settle with a judge, sometimes they settle just because the parties are willing to sit down and resolve a dispute. The statistic is roughly about 90 to 94% of cases that are actually filed in our system get resolved one way or the other through some form of settlement. Mediation is a big part of that process for my practice and for many lawyers that handle civil cases. But as Ken alluded to, it's not just related to civil matters involving money damages. A lot of times it's involving divorce and child custody and those type issues. Right. So it can be applied in a lot of different contexts with a lot of different types of cases with great success.
And are there different types of alternative dispute resolution?
Well, there are, David. Mediation is the most commonly known, but what people are finding more and more is that if they've signed a consumer contract, if they've signed an employment contract, they basically obligated themselves to engaging in another type of ADR, which is arbitration. And what arbitration is it's like having a non-jury trial by a person like me, some neutral person who doesn't take sides, but I act as a private judge, in effect, to decide and resolve the particular case. And arbitration has really become more and more a part of our lives as lawyers and really as consumers, because you can't even buy a car today or get a credit card without signing on to an arbitration agreement. So ADR involves both mediations, it involves arbitrations and other types of ways of resolving cases before you get to court.
From a civil lawyer's perspective too, David, arbitration used to be something that we really didn't want to talk about, we didn't like. And what's happened is I think a lot of lawyers on the from the civil perspective have recognized that arbitrations are more efficient, they're less expensive, they're quicker, and it's a fairly efficient way to get a result. Is it as good as the option to have a jury trial? Most plaintiff lawyers would probably tell you not. However, there are circumstances where arbitration is the preferred means to resolve a consumer dispute or dispute. And that's a whole nother area of the law. There are ways to beat arbitration provisions. There are times when you have to arbitrate. At the end of the day, as Ken's talking about, their practice group includes both individuals that are objective arbitrators and also mediators. And one of the things I think would help add some context is talk about a typical mediation, for example. If I'm bringing a case to your practice with, let's say, a defendant in a civil case, explain kind of what happens in the process, because I do think, Ken, the people watching want to understand the process and how it actually works.
Well, I'm glad you've asked me to do that, because I think it is important for people to understand what the process is. They might otherwise have a lot of fear, and concern and anxiety about going into a mediation. First of all, they need to relax. An arbitrator or mediator act in different ways, but as a mediator, I don't have the power to impose a solution on the parties to decide a case, unlike an arbitrator. So in a mediation type sense, what my job is to get everybody calmed down and focused on what the benefits are of resolving a case. So we do this basically by walking everybody through an understanding of what they're going through. So I'm going to spend time right at the outset explaining what a mediation is. Then I'm going to give everybody an opportunity to basically state their case, to give me an understanding of what the case is all about. Often a lawyer like Josh will have provided me information about their case ahead of time so I can read it and understand it. Sometimes it doesn't work that way. So we make time for that in the mediation process. Then I split everybody up, and usually the plaintiff will then make a proposal to settle the case. And what you find is that the parties are like this far apart. Right. Step by step, we go back exchanging proposals so that difference narrows from this much to this much to this much, and usually that's where I earn my money. And I say that because there's usually an impasse or a gap between what the parties want to accomplish. So what I've got to do then is to make sure that I've come up with creative ways, that I've done my job of providing feedback, of making suggestions on how you close that gap. And that's where all the mediations eventually run into some difficulty, where you've gotten some momentum to get to this point, but the real test is, can you close that gap? And so I take pride in my ability to try to help the parties come together to close that gap.
We go to great mediators like Ken for that reason, because he's the type of mediator that has the ability to work with the parties objectively to explain why the gap needs to be closed.
Right, yeah, good stuff. Learning a lot here about alternative dispute resolutions, and we will continue to do so. Don't forget that even throughout the show, you could call, text, or email your legal questions directly to our panel of experts. They are here to offer their expertise and help you solve your legal battles. Contact them 24/7, and we might feature your question on the show. You can also fan them on Facebook. Just search for Hollis, Wright, and Couch. Follow them on Twitter. That is Hollis_Wright. Much more on this topic. The attorneys are coming right back.
I'm Josh Wright with the law firm of Hollis, Wright, and Couch, and thanks for watching The Attorneys on Alabama's 13. Now, we hope you, a friend, or a loved one never need legal counsel for a case. But if you do, the goal of the show is simple. Provide answers and legal counsel when you need it the most. Your call to the show is free, so if you have questions specific to this show or related to other civil legal matters, call, email, or text us to talk with one of our lawyers.
Those firm facts certainly helpful. Our topic of conversation tonight has to do with alternative dispute resolutions, and we would love to include you in this conversation all throughout the program. There are ways that you could get in touch with us. You'll find that information on your screen, and we will be sure do our best to get those questions to our panel of experts. One of the firm facts, gentlemen, going into that break was about the process being non-binding. Help us understand that.
Go ahead, Ken.
Sure. What's non-binding about a mediation is that it's really up to the parties to decide what the outcome is going to be. That is, as a mediator, I can help get you there, but I can't make you drink the water.
Right.
So it's really part of my job to get you to drink the water, but you can always say no. Most people do say yes. Well, they want to resolve their case, and in fact, when you look at the statistics, you'll see that about at least 75% of the time, the parties agree to settle their case through mediation. But there are times when your client is going to want his or her day in court, and they're entitled to that. And that's the beauty of mediation. They are not obligated to reach an agreement. Often people will get to the mediation and discover that either the proposal that's offered is just not attractive enough,
right,
or that they really want someone to hear their case. Yeah. And our system allows them to do that.
So, and that is one of the questions that we've got here. If you do want your day in court, can you be forced to settle your case?
You really can't. You can be forced to mediate in some circumstances. Courts do have the power to order the mediation in some circumstances,
right,
but never can you be ordered to settle.
A lot of times, David, what happens in practice, and I know Ken sees this a lot, cases mediate more than once. Sometimes there's a mediation, there's some success, but the case is not resolved. The parties say, I want my day in court. They go litigate a little bit more. They take some depositions, which are these under oath statements that we take of people. And then later they'll come back after they gather more information about the case and more context about the case and the circumstances. They'll mediate the case again. I've been involved in cases where we've mediated 4 times, maybe 5 times before a case is resolved. It doesn't always work that way. Sometimes it's very efficient one time. But mediators like Ken are there for the long haul. They don't just start the case and then walk away from you if they're unsuccessful. They will continue to kind of keep up with the case and make sure that they can fill in. They're happy to do so and try and get the case resolved for them.
Another question we've got about confidentiality. Are the mediations confidential?
They are confidential. In fact, we have very strict rules that we operate under as mediators and the parties when they come to a mediation. And the confidentiality rules basically say that you can't talk about the proposals that are exchanged or the outcome of the mediation. Even if you were to go to court after the mediation is unsuccessful, the parties just can't tell the judge what happened during the mediation other than the fact that the mediation worked or didn't work. But when you're discussing proposals and you're exchanging offers, you don't want a jury or a judge to know that one side or another offered to do this or that, because that might bias that jury as to what your position is. So to protect the parties, the rules say that everything has to be kept confidential.
And one of the unique things about that, one of the benefits of that is, from a practitioner's perspective, I look at it without prejudice, meaning that it is a without prejudice meeting where I can hear the position of the other side, they'll hear my position, and there are times in mediation that we will actually disclose bad facts for our own case, that we recognize are issues that we have to deal with that may not be addressed in front of the jury the same way. But it's without prejudice in a mediation where it can never be used against you. So you're able to fully and completely evaluate the case and fully and completely negotiate and discuss the good and bad facts in your case. So there are really a lot of benefits to the confidentiality of mediation.
Exactly.
Really are.
Are there certain types of cases that kind of lend themselves more favorably to mediation rather than a jury trial?
I think, pardon me, I think what we find is that just about any kind of case can be mediated.
Right.
For example, if you've got a car wreck case or a nursing home case where someone's been injured in a nursing home, or even a commercial dispute, the chances of being successful at a mediation are about the same.
Right.
So the way that we look at it, if you've got a child custody case or some complex construction dispute, it really doesn't matter. What matters is whether the parties are willing to work towards getting a resolution.
You know, and David, one of the interesting things about mediation that I really do like about mediation is mediators really kind of look at cases from a business perspective, which is there's business in litigation, there's business in resolution, and an emotional side. A lot of times when somebody's not been involved in the litigation process before, they've been injured, let's just say a car accident case, it's an emotional time for them. And I respect that. I understand that. They've been injured. They're a victim. They feel like they deserve a day in court. And I get all that. And the mediator does too. What the mediator is able to do, though, which is really interesting, is he's able to take the emotion out, focus on the business. That doesn't mean the emotion's gone. The emotion's there if you get your day in court. But to focus on the business side of the case to determine whether or not the case can be resolved. And a lot of times, one of the reasons I think that mediation is so successful, David, is because people will set emotion to the side, look at the business aspects of the case, the positives and the negatives of the case, the potential you could win big, the potential you could lose big, and that's where people come to middle grounds. And that's what one of the unique things about mediation.
And David, I'd add this thing. There's another side to the emotional component of a lawsuit. Not only is it an emotional situation in general, but when you think about the impact of emotions on each party to a lawsuit, you realize that if they don't resolve the case at some relatively early stage, they've got to live with that case with all those emotions for a long time. Right. Yeah. And it may be a year or 2 or 3 years before their case comes up for trial. And during that period, they're going to find themselves thinking about that case all the time. They'll find themselves unable to sleep at night without thinking about it. So it wears on parties to lawsuits, the fact that the lawsuit is pending. Mediation is the way to resolve that without having to go through that kind of emotional trauma.
We often talk about the fact that litigating a lawsuit and resolving a lawsuit, it doesn't fill the gap that you've lost because of your injury. Right. What it does do is it provides closure. And Ken's talking about closure. And closure is a good thing for people when it comes to suits.
Don't you think, don't you bet Ken's children hate arguing with him? There's really no chance.
He's too logical, too rational. That's right.
This is not going to work out well.
That's right.
Hey, as we head to break, don't forget you can call, text, or email your tough legal questions directly to the attorneys here to offer their expertise. Contact them 24/7. Just might feature the questions on the show. You can find them on Facebook. Just search for Hollis, Wright, and Couch. Also on Twitter, that's Hollis_. Our final segment here on The Attorneys. Even as we are wrapping up this show, would still love to hear from you. You can email your questions 24/7. Also find the firm Hollis, Wright, and Couch on Facebook as well as Twitter. So be sure and get in touch with us. You know, this topic of mediation, and I say it as we were in break, kind of jokingly, 1 of 10 in a family setting, you get a lot of experience at mediating. But taking emotion out of a cause of dispute, that seems so difficult.
Well, it is, but let me just give you this perspective. As Josh can tell you, lawsuits definitely involve very powerful emotions, and that can carry over into a mediation, and you would expect that it would. The mediator has to be prepared for that, however. Let me give you 3 words: matching, pacing, leading. Now, here's why I'm giving you those words. Think of not 10 kids as in your family, but a herd of horses. And one horse breaks away. Well, some horses are trained with their rider to go and match that horse that's broken away. And so that emotion, as in a mediation, is matched. Then that horse brings the other horse back into the fold by pacing. And then finally, that horse that's gone astray is led back onto the right path. So that's what I think of as a mediator's job, to not beat the parties up when they're in distress already, but to match them, that is to connect with them. And then to pace them back, you know, in a gentle way back into thinking rationally and getting those emotions down, and then finally leading the parties, that emotional party and all parties, into a more productive path resolution.
I think most lawyers would tell you, too, that the best mediations are those where the plaintiff is a little unhappy and the defendant is a little unhappy. Ultimately, that means neither of the parties got exactly what they wanted.
Right.
But ultimately, they got closure and they got to resolve the suit itself. And, you know, one of the things that we've talked about and touched on related to mediation is it actually serves an important role in our legal system. Right now, the way our system is clogged up, and we've had judges on and we've talked about these topics about how the system is backed up and how slow and how long it takes sometimes to get cases from start to trial. This is an efficiency on the system, and it helps resolve claims that never have to go further through the system. And so it takes claims out of the system, allowing others to get through more efficiently. So it plays an important role, too.
Let's try to buzz through some of the questions. We've got one. How long does a mediation take?
Well, typically, a mediation is going to last anywhere from half a day, as in a relatively simple case, to at least a full day with a more complex case where you've got either more money at stake, or the issues are more difficult, or the emotions are high. But typically it's a half day to a full day. But there are times, as Josh mentioned earlier, when you're not going to get it all worked out that day. And what we do then is we don't let the parties just go out on their own and try to work it out, but we stay in touch. You know, we call them, we try to take their temperature from time to time to see if there's another opportunity either to get back together in a mediation setting or to exchange proposals over the telephone.
We've talked a lot about mediation. What about arbitration? What is arbitration?
Well, arbitration really, and Ken can describe it probably better than me, but arbitration is allowing a single objective individual like Ken as an arbitrator. Sometimes you'll have a panel of 3 or 4, but let's just say it's one person. They ultimately hear the case from start to finish. They are the judge, they are the jury.
Right.
And it is as we talked about earlier in our first segment, a more efficient in many circumstances and a less expensive way to litigate cases in many circumstances. And ultimately, you're trying your case to the arbitrator, and the arbitrator is taking the law and the facts, weaving them together, and coming up with a conclusion and ultimately a result, whether it's for the plaintiff, for the defendant, for both. It could be a lot of different circumstances.
And before we get to the final thoughts, anything you want to add on arbitration?
Just that it's supposed to be a quick and more practical way of resolving cases than going through the entire jury trial process. With a jury trial, you've got to be very careful about the kind of evidence that you put in. It's got to meet certain standards.
Right.
You've got to be, you're very constrained as to exactly how the case is going to be worked out. In an arbitration, the rules of evidence aren't quite as strict. So the arbitrator then has the ability to maybe focus more on how this matter ought to be resolved. Right. And that's the power of arbitration.
Generally binding. It is a binding process. So once the result's there, it's binding. You can appeal it, but it's generally binding. About
out of time. Fascinating conversation tonight. Final thoughts from you, Ken?
Just simply that ADR, or alternative dispute resolution, is a way to give the parties control over their own disputes.
Yeah. All right. And Josh?
Yeah, you know, I think it's an efficiency on the system. It's a necessary on the system. It's something that lawyers deal with on a daily basis. If you have a lawsuit currently, talk with your lawyer about these alternative ways to resolve a suit. Mediation is a great mechanism to use to resolve suits. The numbers speak for themselves. 92% of all suits filed ultimately resolve. 75% of those that go to mediation have an opportunity to resolve. So, you know, using mediation is a very good process.
Ken and Josh, thanks so much for being with us.
As always.
Thank you.
Appreciate it. I see why you call. Ken.
That's right. That's right.
Good to meet you. Good to see you once again. And thanks so much for being with us. I want to thank you as well. I want to remind you that you can call, text, or email the legal questions to the Hollis, Wright & Couch Law Firm. Also fan them on Facebook. Search for Hollis, Wright & Couch and follow them on Twitter as well. That is Hollis.